Straight ahead on Law&Crime Daily. A suspect finally arrested in the cold case of a 9-year-old's disappearance, the kidnapping that scared parents across the country.
It was so brazen, so ruthless, but clearly planned.
A father accused of decapitating 2 of his children, why he appears more concerned with his own treatment in jail.
They're trying to kill me. Why, you would be focused on this situation too if they were trying to kill you.
Plus, a husband agrees to tell police where he disposed of his wife's body. Our experts take on the controversial deal. And an update in the Pike County Massacre case. We bring you inside the hearing for one of the suspects charged in the Ohio murders. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmire along with Terri Austin. A California man already in prison for 3 murders has been charged with the disappearance of a missing 9-year-old girl. David Misch is charged with murdering and kidnapping Michaela Garrett. Michaela disappeared from a neighborhood market in 1988. Investigators took a fresh look at the case on its 30th anniversary. A partial palm print found on her scooter reportedly matched to Misch. Investigators believe Misch snatched the little girl as she went to get her scooter outside the store and forced her into his vehicle.
She and her friend rode to the local market to get some candy and sodas about 10:15 in the morning. They were just kids, carefree, certainly unsuspecting of the danger that lay ahead. Michaela's kidnapping devastated her family, paralyzed them with grief, and terrorized them with the unknowing of what happened to Michaela. Her kidnapper moved one of the scooters away from the store to the back area of the parking lot. He did so to isolate and be able to grab Michaela when she came to pick up that scooter. She has never been heard from or seen again.
A fingerprint examiner saw Misch's name on the possible suspect list and painstakingly compared his to one found on her scooter.
That's part of the collaborative effort. The Fremont Police Department opened up their file and allowed us access to a case they'd been working. Obviously, the one we mentioned earlier, the double homicide. We also had the partial palm print, and through painstaking direct examination of that print, we were able to identify this suspect as the perpetrator. It wasn't a print that we could run through the system. It had to be manually compared. And so once the link was made to this as a possible potential suspect, then a direct comparison through literally eyesight had to be made to compare the 2 prints. Well, the Fremont case, the crimes that this man allegedly committed were a little dissimilar from child abduction. So there were no pointers that led directly to this suspect, other than the tireless effort of the detectives investigating it. And they followed through with thousands of leads.
The defendant has a long criminal record, and prosecutors are seeking to enhance his charges in this case.
He is charged with murder of Michaela Garrett. We have also alleged 2 special circumstances. The first one is that Michaela was murdered in the course of a kidnapping. And the second special circumstance is that David Misch has been convicted of a previous murder. The complaint also alleges that David Misch has been convicted of 2 prior felony convictions, one for assault with a deadly weapon in 1982, and one conviction for commercial burglary just 3 months before Michaela's kidnapping. As the chief said, David Misch is currently in Santa Rita, a pending trial on a multiple murder involving 2 women. He is currently serving time in state prison for the murder of another woman in 1989.
Police then read a statement from the victim's mother, who says she's grateful her daughter's kidnapper has been finally identified.
I feel as though I am looking for Michaela, but now I don't know where. I honestly feel lost in the dark. Over the years, I have often wondered whether I really wanted to know the truth of what happened to Michaela. I wondered if I would be able to take it. When I received the news of the kidnapper having been identified, I asked the hard questions of Detective Purnell of what method this man used to kill his victims, and received answers, and they were not easy. When I had doubted whether I would want to know, it always come back to, if Michaela could experience it, I could hear it. Because it's not about me. It's never been about me, about my feelings. It has always been about Michaela.
Joining me now is criminal defense attorney Mike Koribanicsa, along with Terri Austin. Mike, Michaela's remains have still yet to be found, and the case rests on this whole partial palm print. As a former prosecutor, how strong do you think this case is?
These cases, I have seen in recent time these cases become much stronger when there's not a body recovered because of forensics. I always think it's a great risk, though. It may be just the old school in me, but it's not an easy case for a prosecution when there is no body.
Terri, based on that, do you see the family getting their day in court, or perhaps the defendant pleading out? I mean, he's already in jail for another murder.
You know, Brian, it's entirely possible that the family might still have their day in court. Of course, he could always plead out, but I think that if a prisoner is in custody and he's been identified as a perpetrator in an older case, and as long as the statute of limitations hasn't run, he, of course, can be prosecuted for that crime. The statute hasn't run here because this is a murder. And so I think that it should be prosecuted. It would give the family more closure.
Of course, we'll keep eyes on that, seeing how developments progress. Maybe they find more information, more evidence that connects Misch to the incident at hand and the death and kidnap of this young girl. And now to a case you've got to check out. Police in Pennsylvania need your help finding a suspect accused of shooting an officer. Allegheny County police say suspect Koby Lee Francis kicked out a window of the vehicle during his arrest for violating a protective order. The officer attempted to remove Francis from the car when he was shot 3 times. The officer is currently in the hospital in stable condition. Francis fled the scene. Anyone who sees him is asked to call 911 immediately. Still ahead on Law and Crime Daily, a husband accused of murdering his wife is captured after fleeing across the country. So why are prosecutors striking a deal with him? But first, a father accused of doing the unthinkable to his children. Hear what he has to say after the break. Welcome back. A California father is accused of decapitating 2 of his children. Prosecutors in Los Angeles say Maurice Taylor fatally stabbed his 13-year-old daughter and 12-year-old son. He's also accused of forcing his 2 other children to look at their decapitated bodies and keep them in their bedroom for days without food. Fire rescue initially responded to a call of a possible gas leak at the home in Lancaster on December 4th. The fire personnel saw the bodies and called the sheriff's department. Investigators believe the children were killed 5 days earlier. Taylor appeared in court for his arraignment on charges of murder and child abuse.
You understand that? No, I was not told that, sir. I wanted to defend myself, and I never agreed on counsel.
You want to represent yourself?
Yes, sir. I was never briefed on that, and I want to represent myself, sir.
The defendant says he wants to represent himself. He went back to speak with his attorney, and when he returned, said he stands by that decision.
There's been several attempts on my life in jail, and I want to represent myself so I can have this case go as fast as possible. Because if I get sent back to jail today, I'm going to get killed. And I have evidence that there's a hit on me and that the police are involved. And they've already tried to kill me. And you keep trying to make me get a lawyer that's going to delay things to send me back to jail so I'll get killed. And I don't appreciate that. And I don't think it's fair that this is happening. There's evidence that they tried to kill me when they arrested me. I literally had to go to the hospital when they arrested me when I was flying. I don't want to go back into police custody. I want to do the trial now. I don't want an attorney. And there's a hit out on me, and I have proof. It's on social media. And if I have an attorney, he's going to try to delay things to send me back on his prison bus, and they're going to kill me.
The judge warned Taylor that representing himself could be against his best interests. Taylor said he's ready to go to trial now.
The jury will decide if I'm innocent or guilty. I say that I'm innocent. I don't need an attorney. I think that we should just go through this right now and decide if I'm innocent or guilty without an attorney and let the jury decide. Isn't that the Constitution?
Well, you're summarizing it pretty well, except that it doesn't happen on the timeline that you are requesting.
Okay, well, if I get sent back to jail today, they're gonna kill me. There's been several attempts on my life. I've been to the emergency room, and then I wasn't treated properly at the emergency room, so I have to leave early.
Back with me are attorneys Terri Austin and Mike Koribanicsa. Terri, the judge said he wouldn't rule on Taylor's request to represent himself until he gets a mental health evaluation. Based on what you've seen there, how do you think that request will turn out?
You know, I think that was the right decision by the judge. He wants to make sure that Taylor's competent to stand trial. You know, if he is unable to understand the nature and consequences of the proceedings and he can't assist properly in his defense, then I think he won't be found competent to stand trial. And so, you know, I think it's the right decision by the judge, and I think it might very well be that he is found not to be competent.
Yeah, there's a strong possibility. Mike, we've all had these clients speaking in the same manner, and you say, can you even be represented? But let's say he is able to be represented, he is mentally fit. Do you think this is a type of case that someone should be pro se?
He who represents himself has a fool for a client. I don't think any case anyone should represent themselves. The biggest danger in representing yourself is that every time you ask a question, the jury's going to wonder, are you making a statement or how did you know that? You had to be there if you knew that. Very dangerous road to travel down. I think at best in this kind of case, even if the judge says he can represent himself, he will have someone second seating him.
Of course.
An attorney advising him.
And that'd probably be the smart and the kind of like the splitting the baby, for lack of a better term. Allow him to be pro se, but still have a lawyer there at his side. Because like you said, there's some really serious pitfalls that could come up by representing yourself. Thanks, Mike and Terri. Coming up on Law and Crime Daily, a key suspect in the massacre of an Ohio family appears in court. Plus, prosecutors strike a deal with a murdering husband. But is it worth it to find the woman's body? You decide. Next. A Florida man has pled guilty to murdering his wife in exchange for telling police where her body is. Gretchen Anthony was reported missing in March after her blue Mini Cooper was found in a hospital parking lot in Jupiter, Florida. Her husband, David Anthony, fled. A week later, police arrested him across the country in New Mexico. Cadaver dogs alerted to areas in the couple's home and the defendant's Nissan Frontier, but they were unable to locate a body. Now, Anthony is agreeing to plead guilty to charges of second-degree murder and kidnapping in a deal that includes a 38-year sentence. Within hours of the hearing, investigators found remains they believe are Gretchen Anthony. Mike, some would say he kidnapped and murdered someone, and so he should get at least life in prison. But what are your thoughts on the deal to get 38 years in exchange for telling authorities where her body is?
I think it was a pretty smart move by the prosecution. We talked about earlier about the difficulty in prosecuting a case when there's no body recovered, at least my feelings of it. I think a 38-year sentence for a 44-year-old man is equivalent to the life sentence. There's been studies that show for every day spent incarcerated for people, that's like 2 days off your life expectancy because of those conditions. I think this was closure. It got everybody what they needed, and anything more would have been nothing more than grandstanding. And it appears they've taken the consideration of the victims into their process of coming to a decision. I think it was the right one.
Now, Mike's correct. He's hit a lot of the big words there, Terri, closure and talking to the family. The family actually supports this decision. And based on that, is it the right move to let the victims decide the sentence in exchange for something like this, closure?
You know, I agree with Mike. Every situation, however, is different. The prosecution has to work with the victim's family to determine what is best for the victim's family and also public interest. What I will say, though, Brian, it's unfortunate that killers know they have this as leverage. And they often say, well, I will help you find the body if I get a lesser sentence. So to me, they are sometimes manipulating the system, and that I do not like. But I think you have to listen to the family.
Definitely two very distinct and possible ways to look at this. You definitely want to talk to the victim's family in the case, and I think especially when we're comparing to other cases. Not finding the body, that's devastating. I'm glad the family found some closure in that information. Thanks, guys. When we come back, why is it taking so long for justice in the case of a family massacred in Ohio? The court hearing for one of the suspects just after the break. One of the family members accused in the execution-style murders of another family appeared in court. Law&Crime's Angenette Levy was in Pike County today and joins us with the latest in the massacre case.
Yeah, Brian, you know, we expected to hear arguments today from Jake Wagner's attorneys about why they say ballistics and shoe impression evidence should not be allowed at trial, but that didn't happen after all. Now, first off, Wagner arrived late to court. The prosecutor told us that someone at the Pike County Sheriff's Office actually forgot to pick up Wagner from the jail. Now, the judge is still deciding whether Wagner is entitled to a hearing to dispute the ballistic and shoe impression evidence the state intends to present at trial. Wagner, his parents, and older brother are accused of murdering 8 members of the Roden and Gilly families in April of 2016. The state says the motive was a custody dispute over a daughter that Wagner shared with Hannah Roden. Prosecutors say Wagner owned a gun at one time that fired the same ammunition found at the crime scenes and on his property. They also contend that shoes that Wagner's mother bought at Walmart for him and his brother match shoe prints found in blood at the crime scenes.
Just for the record, and I know that we made our opinion clear both in written motion and in chambers, but specifically as it pertains to motions 47 and 48, the state's position is that they are not entitled to a hearing on those matters. So that's, you know, I just wanted to state that position for the record.
Now, Wagner's attorneys have called that ballistic and shoe impression evidence junk science. Meanwhile, they are also asking that one of the special prosecutors on the case be removed by the judge. Andy Wilson is a former elected county prosecutor who now works for Ohio Governor Mike DeWine as a policy advisor. DeWine was the attorney general at the time of the Roden murders and oversaw the investigation. Wagner says because Wilson is involved in policy matters with the state public defender's office, that means he has a conflict of interest. But Wilson says he has actually removed himself from those issues.
I would wonder, though, whether Mr. Wilson retains a responsibility or at least an expectation that he personally would keep the governor updated on all of these proceedings. Because, you know, ultimately the governor will have that final authority as we described in our original motion.
The governor has not intervened in my participation in the case in any way, shape, or form. And there is no reporting duty for me with respect to my obligation to this case. The only communication I've had with the governor really about the case is potential trial dates so that we can plan for how that affects my role as in the policy side of the governor's office.
And Judge Randy Deering is expected to rule on that motion at a later date and hopefully sometime soon. Meanwhile, also today, Jake Wagner waived his right to a speedy trial until October 1st of 2021.
Mr. Wagner, do you feel that you've had an adequate opportunity to discuss your right of speedy trial with your attorneys here?
Yes, sir.
And you feel that you understand your right of speedy trial?
Yes, Your Honor.
And of course, you know, if the court did not afford you a speedy trial, then the charges would have to be dismissed and could not later be brought. You also understand that, correct?
Yes, Your Honor.
Now, a trial date is expected to be set sometime next week, along with a future motion hearing date. We're hearing the talk is they're shooting for an August trial date. The prosecution is insisting on trying Jake Wagner first. Brian?
Thanks, Angenette. My panel is back with me for legal analysis on this hearing. Terry, defense is arguing junk science and waiving speedy rights. What do you make of this appearance by the defense?
You know, I don't think that this is junk science. I think that these, evidence, the ballistics, the shoe prints, I think all of that makes sense. It's critical pieces of evidence. And as long as it was obtained properly, I think it's extremely relevant. So I'm a little bit surprised that they are really questioning that this should be admitted. And as for the speedy trial, I'm always wondering why defendants are willing to do that if they are sitting in jail, which this defendant is. But it happens more often than not, actually.
All right, Mike, maybe you can help us answer that question in terms of strategy. This person is already in. What and why are they waiving speedy trial rights?
Well, there's usually a couple reasons. Number one is speedy trial has many exceptions, and we're, quite frankly, in a pandemic, which has caused a lot of difficulty in representing a client properly. Which brings me to the second reason why I would tell a client to waive speedy trial is this seems like a complicated case. There's multiple defendants. There was a lot of investigation. It is going to take a lot of time to prepare your defense to this case. So sometimes I will tell a client, be careful what you wish for. You may get it. You may get your speedy trial, but are we going to be prepared to protect you the best way we can?
All right, so maybe this is about going through some voluminous or very complicated sources of information. Again, this is a multi-defendant case. Maybe this is a wise move by defense, maybe not. We'll figure it out. What about you, Terry? You said you kind of question it. Does that make sense as to why they might have waived speedy trial rights?
Yeah, I think that does make sense. Of course, he's always going to make sense here because, there are so many defendants.
Thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.